In Wisconsin, people hear the words joint legal custody and assume both parents still have equal rights. They're supposed to. But what if I told you custody and access are not the same thing? There's a psychological phenomenon called institutional gatekeeping. It happens when systems that are supposed to provide access slowly become barriers instead. And nowhere do people feel that more than inside the family court. In Wisconsin, joint legal custody means both parents are supposed to share major decision-making authority regarding the child, medical decisions, education, religion, major life issues. But placement is different. Placement determines where the child physically lives and when each parent sees them. And psychologically, this distinction becomes incredibly important. Because on paper, a parent may technically still have rights, but in reality, if placement is restricted, delayed, supervised, financially impossible to litigate, or psychologically manipulated through years of conflict, those rights can become almost meaningless. Because family court isn't just about law, it's about power, resources, perception, and endurance. And systems often reward the parent who appears more emotionally regulated inside the courtroom, even if the other parent becomes dysregulated from years of loss, litigation, and psychological destabilization. Now add another layer, money. Because one of the quietest forms of gatekeeping in family court is financial exhaustion. Filing fees, guardian ad litem fees, attorney retainers, psychological evaluations, motions, hearings, adjournments, mandatory programs, procedural barriers. At some point, many parents stop fighting not because they stop loving their children, but because the process itself becomes psychologically and financially unsustainable. One of the most controversial and emotionally explosive subjects in family court, parental alienation. Psychology absolutely recognizes that children can become psychologically influenced by prolonged exposure to conflict, fear narratives, loyalty pressure, repetition, emotional conditioning, or subtle relational manipulation. And yet, many parents feel courts fail to recognize these dynamics until the damage is already too severe. Now, when people criticize courts or commissioners, the immediate reaction is often, well, the judge must know something you don't. Maybe sometimes that's true, but psychology teaches us something important about institutions. Systems do not automatically become objective simply because they wear robes. Judges, commissioners, attorneys, GALs, and litigants are still human beings. Human beings with biases. Many parents in Waukesha County and elsewhere describe feeling unheard, financially cornered, or treated dismissively within the family court process, particularly when they raise concerns about alienation or unequal enforcement of custody orders. Because family court decisions do not end when the hearing ends. Children carry those outcomes emotionally for years. So do parents. This is the gray room, where law and psychology collide, and sometimes the greatest distance between a parent and child is created one hearing at a time.